Hello there everyone, how you doing today? I hope you're all well. Today we're going into r/AskReddit, where Reddit bears the question, Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case? And we're going to go over the answers that the lawyers of Reddit provided. If you enjoy, like, subscribe, and leave a comment with your own stories maybe. Maybe I'll read them on the channel. Who knows? Now, without further ado, let's get started. Opposing counsel. Isn't it true you hit victim in the face with a brick? The client's like, no, Marcus hit him with the brick. I hit him in the back with a piece of wood. Braid 100. A buddy of mine's case as a public defender. A gal was busted on drug charges and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop.
Oh no! Omission of details get me in trouble? Who would have thunk it?
My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood. The same detectives on my case and this new theft. They fingerprint the guy, and the fingerprints match the one from my house. At the thief's arraignment, I see him stroll in wearing my suit and tie. I tell the district attorney, and he says there's really no way to prove it. However, the tie he chose to wear was a one-of-a-kind street map of San Francisco, and I still had the documentation to prove it. The district attorney's eyes widen, and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. Little late to the party, but here goes. An obligatory not my client. The company I worked for at the time was doing due diligence before acquiring a small tech startup. The CEO of the tech startup was a well-liked guy in the company, friendly and outgoing, though he had heard rumblings that the COO was rather hands-on with the work, with female employees, if you know what I mean. Apparently, there was a walkaway package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus, because a young woman who worked in their sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers, while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company, without multiple other people present. Those people said his behavior towards her in the meetings didn't raise any flags. The COO denied having any contact with her outside of work. The lawyers asked the question a half dozen different ways, and each time the COO denied any out-of-work contact. Later, we meet with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers, addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said,
But I never had contact with her. It's not like I delivered the flowers myself.
The COO got terminated for cause, so no walkaway package. At her request, the woman was given paid time off until after the acquisition, and then moved to another one of the companies out under our umbrella. Employment case. We get to the deposition of my client, and all sat up. The first question is, please state your name. The client looks at me and says,
Can we take a break?
we do, and she pulls me out in the hall to tell me she's lied to me about her identity. She's apparently a serial fraudster and has changed identity 7 times since the 90s. She apparently thought the other attorneys had somehow figured it out, and that's why they asked the question. Whoo, boy. Lawyer in the UK. I acted for a member of a famous pedophile hunting group. My client was charged with various offenses relating to his vigilantism, most seriously causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in statute or at common law, contrary to my advice. I followed his instructions, as I'm bound to do. If the state won't punish pedophiles properly, then it's left to men like my client to take the law into their own hands. A horseshit argument for a whole host of reasons. His laptop was seized by the police and submitted for forensic examination. He had a staggeringly huge database of CP on it. He himself was a massive pedo.
Ah! No, I don't like that.
Minor traffic cases can be the worst for this, believe it or not, because they are short and simple and often the time the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour and a 55. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those, since her driving record wasn't that bad. When I showed up for her, I found out she'd been driving 70 up on an unplowed snow lane to get around all the other cars traveling in the lane that had been plowed, because they were driving too slow. I didn't even know it was possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed that he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she did claim she just forgotten to mention it. Now maybe I lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour case, and she'd probably just go ahead and pay this one. I legitimately do that all the time during consults. Give my honest assessment if a case is even worth doing, and so by omitting the detail she harmed herself for no reason. At least she took it well and didn't get defensive. Whew. Friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an AC unit and threw it at his girlfriend. My buddy tells her he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they're charging me with assault. I never touched her. I just threw the AC at her. This is bullshit." The judge rescinded the plea deal because of the defendant's attitude and lack of remorse. Went to trial and got a year in jail. The client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing, it came out that they were never a couple, that he was sending sex toys to her on the residence on a weekly basis, and that she never asked for the thousands of dollars he gave her over the years. She was a stripper. We lost, and he got laughed out of court, and he learned a valuable lesson. Tell your lawyer the good and the bad stuff before trial. There's so many. My dude in a custody battle where the opposing party claims he has a drinking problem and he denies it 1,000%. Even after the real talk I have with him asking him not to hide stuff from me. And to be honest, we go into court and at cross-examination, the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys, and then going to pick up his kid from school. Every single access visit. He not only didn't tell me that, he forgot to mention that his ex's brother owns a private investigator firm. Goddamn idiot. Case as a paralegal. It was a negligence case. The client argued that a lack of streetlights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated they found the driver in the driver's seat, pants down, with naughty films on, playing on the phone. It wasn't difficult to figure out who was negligent at that point.
Your Honor, if the cable repairman had simply fixed the cable in accordance with his professional standard practices, my client would have no other recourse but to keep his ostrich in the corral on the evening in question. I rest my case.
A guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction he could only request one modification before anyone's sentence, regardless if they were granted or denied. They swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record, basically finally arrived. He personally filed for modification 6 times since he was sentenced, with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. I am a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, and is ready to be a parent and all that other stuff. After a few months of negotiating with all parties and the Department of Children Court Services, we have a pretrial to try and convince the guardians. I meet with my client before the hearing to see if anything's changed.
Nope, all good. Let's get my kids.
Great, that's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals that 1, he's no longer working, 2, he's no longer in his apartment, and 3, doesn't want to have a relationship with the guardians despite her kids loving them, and 4, won't send her kids pictures of the toys they miss and can't have, 5, plans on moving out of state, and 6, thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant, all in the matter of 15 seconds. I was too shocked to even react. I was speechless. Not the image of stability and parental fitness I've been trying to paint since last July. I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long, drawn-out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple days prior, the couple decided to get back together, and instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, bought-in experts such as land assessors, financial planning people, and they were like,
"Hey, let's get back together."
One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury, and the couple was adamant they didn't think that them getting back together was a detail any of their attorneys needed to know. Yeah, I think your attorney needs to know that. I'd say it's pretty damn important. Anyway, that's the end of today's video. If you enjoyed, remember to like, subscribe, and leave a comment with your stories down below. Maybe I'll read them in a video one day. Who knows? Now, ba-da-ba-ba-ba. I'll see you next time.